Breaking tonight, Talpiot, a judge first opened the door to freedom, then abruptly reversed course with a warning that stunned the courtroom. The message.
Court isn't just about punishment. Sometimes it's about second chances. But those chances come with warnings you can't ignore. What you're about to see is a judge walking that impossible line between mercy and accountability. Pay attention to how he grants freedom while making crystal clear what happens if that trust gets broken.
Violate your probation, and you were revoked to serve your sentence. You were given credit for your time served. You've now filed a motion pro se, meaning representing yourself, for a furlough to go to the Safe Harbor Rehabilitation Center. And you've also filed something for split confinement.
I would like to strike that motion.
All right, that motion is stricken. State have any position on this request for him to be furloughed to Safe Harbor?
Your Honor, I actually said from both the Hope Center and Safe Harbor.
You have both the Hope Center and Safe Harbor willing to take it?
Yes, Your Honor.
Just have a questions.
All right. You want to ask questions? All right, raise your right hand, Mr. Duncan. Let's put you on the oath.
Do you solemnly swear or affirm by the testimony you give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, Mr. Duncan,
Yes, ma'am.
what are you serving the sentence right now?
Yes, ma'am.
For what?
Molecular version.
You feel right?
Yes.
Okay, and was drug or alcohol a contributing factor to you being in this problem?
Yes,
How long have you been incarcerated?
Since December last year.
December of last year, and how much more time have you been incarcerated?
I'm going to be-
A whole other year? And you think that a furlough would say, you've been locked up almost a year, are you sure that you need inpatient treatment? You do? Have you had access to electric alcohol since you were incarcerated? Do you think this is something that you could seek just when you complete your sentence? Maybe go attend some AA or NA?
Yes, ma'am.
Any position that you have now as a result of those questions?
I just feel not sure furlough is appropriate for his recovery. I'll defer to the court, Your Honor. I don't want to.
I just granted a furlough to somebody who hasn't even been convicted. Who's,
And that's very true.
and if I'm going to do that, then somebody who's actually only got a year left to serve but wants to try to get into an inpatient program, it would seem to me that would be beneficial to him. I understand what you're saying. If he's been in jail for a year and hasn't been subjected to alcohol or drugs, you would think he's well on his way to recovery. But you and I both know there's more to recovery than simple abstinence. That this also needs to be dealt with regarding,
Just ask for like break, maybe every 2 months or review every 2 months. Is the hope it's a year-long program? That might be just right.
what.
I said, then that might be just right, Your Honor.
So which one are you want to go in?
I would prefer the Hope Center.
Well, we deal with the Hope Center on a regular basis. And you understand that if you go into the Hope Center and you don't complete that in 9 months, let's say that doesn't mean that your sentence expires in another 3 months. You come back to jail and serve that year.
Yes,
You
sir.
understand that? Yes. In my opinion, he will not get credit for the Hope Center until he successfully completes that. All right, I'm going to grant your furlough to the Hope Center. And Ms. Allen, I'll ask you to help us draw up an order for that furlough. Furlough is one order. It has one purpose, and that's to let you go from the jail to the place that you're going to get this treatment. And if you do that, then you go someplace else and you walk away from that, you've got to go back to the jail. If you don't do that, that is jail escape, a felony. You understand that?
Yes, Your Honor.
So I'm going to give you the opportunity to try to get some help because, number one, you appear to be a fairly young man. Number two, you've almost served your sentence. In another year, you would have served your sentence. So I'm going to give you a chance for the latter part of your sentence to be in rehabilitation and try to help you with that. And if you successfully complete it, then we'll look at whether or not to make you serve the rest of it. But if you don't, then you're going to go back and start serving your sentence from the time that you leave the Hope Center. Do you understand that?
Yes, Your Honor.
All right. And that'll be the
Thank you.
judge moving forward. Here today because this matter has been on appeal, and my understanding is that there's been a request for inclusion in the record of certain items that are not typically included in the record. And those include the jury list, the jury venire, the entire jury venire that's been, that was used to summon the jury for this case. And it seems like there was one other, all of the subpoenas that we issued. Those are not typically matters that the Court of Appeals wishes to have included in the record. And for that reason, after it was remanded or contact was made by the Court of Criminal Appeals to this clerk's office, I set a hearing for today for us to explain, for us to find out why these items should have been or should not be included in the record. So, counsel, you are here today, Mr. Stover. You want to explain to me exactly what it is you're asking to be included in the record regarding the jury?
Regarding the jury, Your Honor, we were asking for the list from which the jurors were selected, not the, in other words, the panel of jurors that were selected.
And what's the purpose of that?
Regarding the race issues that you had.
That issue is not raised at the prelim in this case, at the preliminary proceedings in this case, nor at trial. And it was not raised in the motion for new trial, correct?
Yes, it was raised in the motion for new trial. As you recall, what originally when I amended it, I did not add it in, but prior counsel had. And when we were discussing this prior to the hearing being conducted, I asked that you incorporate both the original motion that was filed along with my motion based upon Mr. Powell's assertion that everything needed to be included. So I asked for that, and then so as part of that issue, I needed to add, I was trying to, get the information in from the record as far as what the race of the panel looked like prior to selection in order to be able to raise whether or not there was an issue constitutionally of whether Mr. Powell had the right to have this trial based upon a jury of his peers, including members that potentially would have been of the same race. Regarding the subpoenas, there was an issue regarding subpoenas. I just need the trial subpoenas, not every subpoena in the case going back.
And you need a copy of the trial subpoenas to be included on the appellate record for what purpose?
The main issue, there's two things. One is the issue about whether the trial counsel issued a subpoena for a certain witness that Mr. Powell asked for him, was told it was going to be issued. And that was discussed during the trial. And then that was part of the issue with the withdrawal request that my client had made, asking for his to get new counsel during the trial, which was denied, part of the basis for the trial. Otherwise, there's cell phone tower records that were subpoenaed by the state, where they were subpoenaed by records of a co-defendant, not Mr. Powell's records. And there's a question as to whether or not that subpoena was issued for Mr. Powell's records as well, and what there was a request thereof. So in the sense that if it can be narrowed, I believe those issues could be narrowed to the satisfaction of the court and the appellate court. That's fine, but those are the two main things, the reason why those items were requested.
Well, my concern is, number one, the appellate court clerk's office advises that those are not issues that are usually included in the records. Those are not items that are usually included in the records. And unless, of course, obviously it would not be something that would be retried on the appellate level. It would only be determined whether or not there was an error committed at trial that would afford a new trial for the defendant. And therefore, we necessarily have to then consider the motion for new trial and whether those issues were raised. The motion for new trial that was originally filed in May of 2023, May 8th, 2023, does raise as an issue that the jury veneer failed to meet constitutional standards for defendants of minority race, and the court should have ordered a new jury veneer be impaneled. But at the point in time that was raised, there was no objection made. My recollection is at trial, there was no objection raised to the panel when the jury was being selected. There was no objection made at that point to raise the issue of race as being a matter that had to be considered. Normally what would be done, and we've done it in other cases, and I think maybe when one of the co-defendants in this multiple defendant case, that we conducted a hearing and had the clerk of the court testify as to the composition of Stewart County as far as the racial composition and so forth, and that there was a finding by this court at that time that there was no discrimination because there was no intentional exclusion of a particular race in the selection of the jury. And we went through how the jury veneer panel was selected and how they were brought in, and it has nothing to do with race. It's a random selection process. The problem is that I don't believe that the jury veneer even includes race as being a factor on in other words, if you got what you want, it's not going to show what the race of the individuals was.
Yes, Your Honor.
So how does that help you in your argument?
It probably would not, Your Honor, and I didn't know that until your order was issued. It indicated that that was the case. But this was an attempt to make sure that Mr. Powell, the issues Mr. Powell wanted raised were raised. So I put that in the designation. With that clarification, I think that does make logical sense. That it makes some sense to add it if it's not going to have the information that would be beneficial even to the argument. Standing the fact that it may not have even had a hearing on it during the trial.
My recollection is that when we had the trial and the people were brought in, there's no indication on the jury veneer of the race of any of the jurors. Obviously, their race would be apparent at the time that we do the jury selection process. And there was no objection, to my recollection, made at the time of the selection of the jury to the composition of the jury. And had there been, we would have conducted a hearing. And as a result of that, the jury veneer contains the names and addresses of the individuals, but it does not contain any racial information. So therefore, I'm going to hear from the state about it before I make a ruling on it. But Mr. Crouch, you're here today, I think, in response to this.
Judge, the state doesn't have a position on the releasing the veneer. I mean, the court is correct. It doesn't indicate one way or the other the race of a person. So I don't know how that would be beneficial. Going to the other issue, the release of the subpoenas trial. My concern with that is that will not be an accurate reflection of witnesses that were brought in. For example, in Mr. Flanagan wanted a rebuttal witness in the middle of the trial. The state assisted in locating and transporting his rebuttal witness. I don't remember whether he actually called that witness or not. I believe that he did. But there would not be a subpoena issued for that person because it was a rebuttal witness that was needed in the middle of the trial. So my concern is that Mr. Stanford is wanting these subpoenas to reflect the accuracy of what Mr. Flanagan did. It won't, because, like I said, he asked for a rebuttal witness in the middle of the trial, in the middle of the stage, after the state's approved. So, other than that, the subpoenas for these phone records, those won't be trial subpoenas either. Those are all issues that were done by either a search warrant or a judicial subpoena well before trial. So it won't accurately reflect trial subpoenas or witnesses.
All right, Mr. Stover, I'm of the opinion that your your motion addresses the issue of wanting to have, or not your motion, but your request to include in the record for the appellate purposes, the jury veneer is going to be denied based upon the fact that I don't think, as I've stated before, there was no objection made to the jury veneer as we began the jury selection. Secondly, the jury veneer information does not contain any racial composition of the jury, and as a result of that, it would not assist you in the information that you were alleging. And that thirdly is because of the fact that people who are called for jury duty, oftentimes we try to protect their confidentiality and their information. So I'm going to deny that that be included in the record. And I don't think it's something that typically is included in the record as well, since there was no issue raised, an objection made at that time. Secondly, on your request to include the subpoenas, I tend to agree with, there were other witnesses brought in that there were no subpoenas, and there was information that was obtained by a search warrant rather than by subpoena. And for that reason, again, if it's the basis that you have said that you want to have the subpoenas issued is so you can determine whether or not there was a subpoena issued for a particular individual or thing, that is in the record. You're welcome to examine the record. But that would, if it failed to meet what you consider to be the competence standards for a trial attorney, that's an issue of whether or not there was insufficient, whether he had competent counsel at trial, and that's not something that's usually done on the original appeal. That's an issue of post-conviction relief. If it is raised on appeal, then it's waived for post-conviction relief, and I know you know that. So for that reason, I think while you can examine the record here and determine whether or not a subpoena was issued, and you can examine the transcript to determine whether or not those witnesses did or did not testify without a subpoena, then I think comparing the subpoena list there and the subpoenas that were issued to the witnesses that testified in trial will help you with that information. But again, because there's no issue that's raised in this appeal as to the competency or ineffective assistance of counsel, I'm not going to include those in the record because they don't normally go up on the Court of Appeals. So I'm noting your request and denying both of those requests, and it's a part of the record now.
Yes, sir. Just to clarify, it's not the ineffective assistance of counsel that's the issue. It's the denial of the defendant's request to have the attorney to obtain counsel or to have their attorney withdraw during the trial, which is denied. It's more narrow of an issue, but I understand your honor.
So that's my ruling. All right, thank you.
Here's what most people don't understand about appeals. They're not about retrying the case. They're about procedure. Did the system follow its own rules? This attorney wanted jury composition records to argue racial representation issues. But here's the catch. Those records don't even track race. The whole request became pointless before it started. It shows how technical the law gets and how sometimes the system's own limitations become the barrier to justice or injustice, depending on which side you're on.
Mr. Allen, Judge. Dana Allen. Good morning,
Dana
Judge.
Allen.
State of Tennessee versus Dana Allen. Mr. Allen's present with what we're making his way forward. First page of the docket, Your Honor. Mr. Allen has applied to the recovery court program, Your Honor. I just spoke with Mr. Beecham this morning. They're in the process of reviewing the applications. I think it's stated that there's been a provisional acceptance, but they're going to discuss in further detail tomorrow. We're just requesting the court reset this to January 12th for a plea hearing. That way, in the event he is accepted into the program, we can have everything in line and ready to go on that January 12th date.
Do they have any opposition?
There you go.
January 12th.
I would just like to understand, just for my own knowledge, I was provisionally accepted November the 5th into the program.
You're asking me to explain how the inner workings of the recovery court process. You're asking the wrong person.
Okay.
Let me explain to you. They have a process they go through that determines someone's past, the charges they're facing, the potential for recovery. They consider all of those. They have a meeting of the board And that board is made up of a variety of different individuals, some of whom are in defense, some of whom are in prosecution, and they have a presiding judge, who our Judge Lockhart Nash is our recovery court judge. She has the final say as to who is going to be admitted into that. It's not an automatic right. And because of the fact that she has the final say, she can request additional information regarding your application.
So I haven't been accepted yet.
You have, it's kind of like when you get a credit card application in the mail.
What you're about to hear is one of the hardest things I've ever had to sit through. This is a victim impact statement from a sexual assault survivor. She's speaking directly to her attacker in open court, 4 years after the assault, 4 years of rebuilding herself piece by piece. I need you to understand this isn't just legal procedure. This is someone reclaiming their voice in the room where their abuser sits. It's raw, it's painful, and it's necessary.
Even being in the same room makes my whole system go over. What you did to me created a trauma that I will carry for the rest of my life. I stand here today only because I refuse to let what you did silence me. This moment has been taking a long time coming. The past 4 years have been a constant roller coaster of emotions, pain, fear, and grief. Most people see September 11th and think of the tragedy of the Twin Towers. For me, September 11th is the day my life collapsed. It is the day everything I understood about safety, trust, and myself was shattered. You stole a part of me that I will never get back. You didn't just hurt me, you hurt everyone who loves me. My family had to watch me fall apart. My daughter was almost 2 years old when this happened. I used to sing to her every night. I used to feel joy and peace holding her. After the assault, a part of me disappeared. I stopped singing. I could barely get through a bedtime story without breaking down. I cried for months, trying to understand how another human could cause this kind of pain. I couldn't sleep. I couldn't eat. I would become physically sick from flashbacks. I tried so hard to hide my suffering from my children, but any moment I had alone, I completely fell apart. I began having severe panic attacks. Before this, I had never known anxiety or depression. After the assault, it became my reality. The emotional damage was overwhelming. I felt helpless. I felt unsafe in my own skin. I questioned my worth, my identity, and my place in this world. I suffered a miscarriage the same week you assaulted me. A loss that compounded everything. I had trusted you. What you did felt like the deepest kind of betrayal. What happened changed me forever. It changed the mother I am, the woman I am, the person I thought I would become. I am still rebuilding myself piece by piece. This may be the only justice the court can give, but it is accountability you earned by your own actions. I hope you understand even a fraction of the damage you caused. I hope you never do this to another person again. I hope the people in your life are never forced to experience the pain I have lived with every day since that night. I do not ever want to see you again. I'm here today because the pain you caused deserves to be spoken. I deserve healing, and today speaking this truth is a part of that healing. Thank you.
Mr. Clary, come back to the podium. All right, this case was before the court some time ago and went to trial on the original charge, and a jury was unable to reach a verdict. It was a hung jury, and the matter has continued to be pending on the case. For that reason, pending on the court's docket, and for that reason, the state has agreed with the consent of the victim to amend the charge to allow for a disposition. Based on this court's finding that it's in the best interest of the victim in this case to dispose of the matter and put it behind to the extent she's able, then I will accept this plea. Dylan Clary, on your plea of no contest in docket number 2023 CR 64 to the amended charge of aggravated assault, a Class C felony, you're found guilty, sentenced to 4 years in the Tennessee Department of Corrections. That would be suspended for supervised probation. You would have no contact with the victim in the case, either directly or indirectly. And you are, as a condition of your probation, to enroll in and complete a 26-week program of batters intervention program. And that will be a condition of your probation. You can transfer your probation to Henry County. Thank you.
Thank you, Your Honor.
I had to pause after that, because how do you move forward after hearing something like that? She talked about how she stopped singing to her daughter, how panic attacks became her new reality, how she suffered a miscarriage the same week as the assault, and she stood there and spoke it all out loud in front of him. That's not weakness, that's the opposite. This is why victim impact statements exist, not for revenge, for accountability. For the record to show this is what you did, these are the lives you shattered.
You can choose to pursue a life filled with drugs, and we'll see you in here periodically, and we'll send you up to prison for a while, then you'll come back out, and then we'll send you back again or we'll find you dead somewhere because cocaine is now being laced with fentanyl, and that happens. And I'll tell you a story. I had a case over in Cheatham County where husband and wife were going to celebrate they were a young couple like you, and they were going to celebrate their anniversary. Great time to be in love and to celebrate their anniversary. So the wife communicates with the husband and says, I've got a bottle of wine. Why don't you see if you can get us some Coke? So he goes out and he buys some cocaine, brings it back. Unbeknownst to him, that cocaine is laced with fentanyl. They found her dead inside the house, and they found him dead out in the driveway. They celebrated their anniversary by using drugs that killed them both. Because when you put that substance into your body at 24 years of age, you don't know where that came from or what's in it. And it could be rat poison for all you know. So you choose from here on out whether or not you're going to live and try to be a productive citizen, or you're just going to live your life teetering on the edge of prison or death. You understand that?
My daughter very much like me alive, so I think I'm almost 3 years sober off that.
Oh.
So.
If you have a child, then you have a real reason to avoid that, because the other thing that I'll tell you about is that people who have drug problems oftentimes don't take care of their drugs, and they get their children exposed to drugs. Then their child, if the child lives, is going to have problems, and likely you're losing custody of your child and so forth. So it all boils down to you making good decisions from here on out at 24 years of age. I vaguely remember what it was like to be 24, and I'm not saying I made the best decisions, but I can tell you I didn't use cocaine. So I will tell you that you need to go through this case and make sure you follow all of the recommendations, because this is your one chance to get probation. If you violate this, you know what's going to happen. You're going to go to jail. You're not going to get any other consideration. I find you guilty of possession of cocaine in a misdemeanor amount. Sentence you to 11 months and 29 days in the county jail. That will be suspended to probation. You are, as a condition of your probation, ordered to undergo an alcohol and drug assessment and follow the treatment recommendations that they give you. Good luck to you. I hope you've learned your lesson.
Your Honor, I noticed that as part of the agreement, Your Honor had advised her she had the right to a trial, proof beyond a reasonable doubt. I'd advised her, because this was a revocation of judicial conversion, that you had already convicted her and that this was an agreement as to sentence. That's not the.
Well, I've revoked your judicial diversion, which is different than you necessarily being found guilty of something. So while it may sound as though I found you guilty already, that's not necessarily the truth. But the evidence is there to find you guilty of this offense. So, all right, and that's the judgment of the court.
That judge just told a 24-year-old the truth nobody wants to hear. You're playing Russian roulette every time you use cocaine now because fentanyl is everywhere. That story about the couple celebrating their anniversary, both dead, that's not a scare tactic, that's the reality. She has a daughter, she's at a fork in the road. And the judge just showed her both paths, life or the edge of death and prison. What she does next will define everything.